Texas Code of Criminal Procedure 3.02. It is part of our law. It is very short. It defines the nature of criminal actions, is what it says. It declares that a criminal action is prosecuted in the name of the state of Texas against the accused. This action is carried out by an individual acting under the authority of the state and in accordance with its laws. The provision emphasizes the state's paramount role in ensuring justice and maintaining law and order. Let's look at the essence here. The essence of Article 3.02 underscores the fact that criminal actions are not pursued by individual victims seeking retribution, but by the state on behalf of all the citizens in the county or the jurisdiction. This approach aims to uphold the collective interest of society and maintain a fair and impartial legal system. The state's involvement ensures that the legal process is executed in adherence to established laws, promoting consistency and uniformity in the pursuit of justice. One noteworthy aspect of Article 3.02 is the explicit statement that criminal actions are prosecuted by the state against the accused. Victims, despite being directly affected by the offense, are not classified as parties to the criminal action. This legal distinction is crucial in delineating the roles of the victim and the state in the criminal justice system. Here's a quote from Willover versus State from the Texas appellate courts. The prosecutor makes the charging decision, not the crime victim. The prosecutor represents the state, not the crime victim. Criminal cases are brought only after investigation by peace officers, prosecutors, and in felony cases, grand juries, whose roles are clearly defined by statute. While victims undoubtedly play a role in providing testimony and evidence during criminal proceedings, they do not have the authority to decide the fate of a case. The decision to dismiss a case or proceed to trial lies firmly in the hands of the state and the prosecutor. This framework is designed to prevent private interests from influencing the course of justice and maintain the state's responsibility for protecting the overall welfare of society. By placing this responsibility of criminal action squarely in the state's shoulders, Article 3.02 seeks to balance the scales of justice. The state, acting through its representatives, is tasked with assessing the evidence, considering the public interest, and determining the most appropriate cause and course of action. This ensures that legal decisions are made with an eye towards the common good rather than individual interests. Okay, that's what, in general, you would hear. But oftentimes, we know from looking at the system that it is not particularly fair. I think the most difficult thing when you've got a victim that doesn't want to prosecute and the prosecutors want to prosecute anyway, it can be a delay. It may be a case where the prosecutor knows that they're not going to eventually prosecute it, but there's a delay in dismissing the case because there needs to be a full review of the evidence. This is what I talk with clients about mostly in these types of cases where there is no crime that's been committed. All the parties involved know it, but the police have still made an arrest, and it'll be the prosecutors who have to make this final decision. That can be a very frustrating thing for clients, but it is part of the law, and Article 3.02 gives us part of that. Another thing to note, if we look at Willover versus State from the Texas Court of Criminal Appeals in 2002, the state, not the victim, is the party opponent of the accused in a criminal proceeding. That's true. And the court in that case said that it doesn't allow for admissions by a party opponent. That's an important part of evidence law, which we covered in some blogs earlier. And evidence law says that you can admit into evidence any statement made by the party opponent. So the prosecutor or the state will get to admit anything that the defendant says. But can the defendant admit any statement by the victim? No. It may be hearsay. It is not excluded under the rules of hearsay 801E2. It is not an admission by a party opponent, so says the Texas Court of Criminal Appeals.